Hi there, this is Billy Tarasio with the Modern Divorce Podcast, joined once again for a celeb dish, although this is going to be bigger than that, with attorney Darren Colburn. Darren, welcome to the
I can
show.
be Goldberg.
Colburn.
Darren Goldberg reporting for duty.
How are you doing today?
I'm doing great, and I'm excited to talk about this one. So let's get to it.
It's juicy, yeah. So, this week's podcast is inspired by the drama between Sofia Vergara and her former fiance Nick Loeb. Darren, why don't you give us some high level background on this, and I'll fill in the details.
Yeah. So during their engagement, the two of them created an embryo that was being stored, and basically for the last 7 years, they've fought over what to do with this embryo. Loeb is in favor of having it awarded to him so that he can use it to create a child. And Sofia Vergara is against that and is like, hey, you can't use this embryo to create a child without my consent, and I don't consent. And I believe that they originally had a court battle in California, and the California court decided with Sofia Vergara and Mr. Loeb.
I
Then,
think they dismissed the claim. They wouldn't hear it. Now,
okay,
what's
they didn't hear it.
Yeah. So what's interesting is there's no divorce. So in other contexts, this comes up as a piece of property to be divided in divorce. But when you don't have a divorce, it makes it even harder to get this case in front of a judge, because to get in front of a judge, for anybody who's not a lawyer, you have to have a cause of action. And that means a breach of a contract or some duty or a divorce. A divorce gives people the ability to get this issue in front of the court. But in their particular instance, there wasn't that. So California said, we don't want to hear it.
Right. And I'm not. So, one thing that's interesting that I've kind of read, and we'll get to this later because there's been some recent cases in case law in Arizona. But my understanding from that case is, and I think this applies in Sophia's case, but when you get these celebrity cases, they don't necessarily talk about all the legal nuances. They just kind of talk about the headlines. But my understanding is anytime you create an embryo, the facility that stores that requires you to sign a contract. And part of that contract, they basically say what happens if there's a decease of either of the donors or, a separation or divorce. So, and I think from my kind of tangential resources, that is the case here. They basically said uh, they both signed they both signed an agreement with the facility saying that we can't use the embryo unless the consent to create a baby unless the consent's mutual. So that's kind of something that is underpinning all of this, that none of the headline type stuff that you read online will say. Yeah.
Okay, so I'm really glad you brought that up. So let's, because I didn't know that in this case, and I'm not
Yeah.
sure if each facility is required to have this language or if only some do. But there's certainly been litigation about this. And so what you're saying is there's a contract between Sophia, Nick, and the facility that froze or created the embryos. And that contract says you can only use the embryo if both people agree. So if Nick then goes and sues for, let's say, a breach of contract, she could then file something like a motion to dismiss saying, I didn't breach the contract on its face. It's very clear. And
Right.
that could be why California says, nope, we're not even going to hear this.
Yeah, because the contract controls, you don't even have a claim. He tried to argue that he was under duress when he signed the agreement. And if you've been following the podcast, you know that duress is not a great argument to have in your quiver. If you're down to the duress territory, and
You
that's
got
not
a
to say
weak
that
case.
duress isn't. It's real. I mean, duress is real, but it's not something that you know um, you're excited to litigate because it's an uphill battle.
So this was 7 years ago, but Nick did not give up. Nick then, I think somehow either the embryos were already being stored in Louisiana or he got them moved to Louisiana and took a very different approach, a very different legal strategy. And his legal strategy now is that the embryos should have an standing or an interest themselves. He even tried to form a trust with them as the beneficiary to give them personhood and status. Now, as you can imagine, when you start making arguments like embryos are people, um, everybody's the hair on everybody's neck goes up and people get very interested.
Right. It basically becomes politicized. It becomes abortion, or pro-life versus women's choice argument, and that definitely occurred here. Nick Loeb characterized her unwillingness to give him the embryo as basically tantamount to her killing a child, and he got very active in some anti-abortion movements and was involved in creating a film, and is among other things. So definitely tried to politicize the issue. What I think is ironic about that is, he signed a contract um, saying what would happen. So if he's so, anti, if he's so pro-life, why would you sign the contract in the first place? So
So, do we know what the circumstances were that he claimed constituted duress?
no, I don't know that. I just know that was his claim. Uh, yeah,
So
but I imagine
ultimately,
that they weren't strong, given that the California court dismissed.
right, right. And ultimately, so yeah, he got very it got very political, it got very nasty. It took 7 years. He accused Sophia, who's a Catholic, of being, a bad Catholic, and there was really nothing was off limits for Nick in trying to have the right to use these embryos. And it brings up all of these very interesting philosophical arguments about who should get to use embryos and who should get to decide whether embryos should become a child. Which interest is greater? The interest of
Right.
the person who wants to have a baby or the interest of the person who doesn't?
Right. Can you hear me?
Yeah, I can hear you.
Sorry, I think you cut out a little bit there. Just doing a little sound check. Yeah, no, it's interesting. I think, and in fact, that brings us to the court case in Arizona, which is interesting, because in that case there were two parties: a gentleman with the last name of Terrell, and a lady with the last name of Torres, and they actually became married. They had embryos because she had to get a double mastectomy. She had breast cancer, and she wasn't sure if she was going to have reproductive issues after that. So they created the embryos and stored them. And then upon dissolution of their divorce, they couldn't agree what to do. Torres wanted to keep the embryos because this is my one chance at becoming a mom, right? Terrell, the gentleman, didn't want to have anything to do with having a child. It's funny. He also claimed in a roundabout way that he did. He didn't. I don't think he used the words duress, but it was kind of a similar argument that he only agreed to it at the time to create the embryo because he felt bad for her, and it was an emotional decision. But as he's kind of, years later, he was concerned about, he made a statement about, whether the child's coming of age and then trying to find me, or child support. At some point this is going to come back to bite me in the bottom. One thing I found was really interesting in the articles I read on that case, was that Torres really tried to negotiate everything she could. She told him, I won't hold you liable for child support. If you don't want to be involved, you don't have to. If you do want to be involved, you can be, right? She even offered to compensate him for use of the embryo. She offered him the entirety of her retirement account
Wow.
in exchange. And he just did not want anything to do with it. So people feel very strongly, because even if you're not on the hook for child support, and you still know that you have this kid out there. And so the issue came before a judge that I know that we both had cases in front of, Judge Ronnie Corbin Steiner. and she applied a balancing test, right, to determine which one of the rights superseded the other. She characterized Terrell's rights as the right not to be forced to procreate, which I think is a discussion that we can have in and of itself. And then there's also on Torres's end, you know, this is her one shot at potentially having a viable child. So you have to balance those. She determined ultimately that Terrell's rights outweighed Torres's right. And so here's what's interesting, and should be a lesson to everyone who ever steps into a family law courtroom. So the outcome that Terrell wanted was for the embryos to be destroyed. Case closed, never have to address it again. The outcome that Torres wanted was for her to have control of the embryos so she could use them to create a child. Well, the outcome that the court did was neither. It said, okay, I'm not going to force this child into existence against your will, Mr. Terrell. But Ms. Torres, I'm also not going to. I'm not going to allow you to use it because of the dispute. And she ordered that the embryos be donated. And then they appealed. Yeah.
And then they appealed
Yeah.
because that is a crazy ruling. And I think the point that Darren was trying to make is when you decide to go in front of a judge, you cannot always predict what they would do. Now, what could the judge have done? One option would be to say, okay, these embryos are like property, the same way pets are. It's a little uncomfortable because, of course, pets and embryos are more than just property, but the judge could have said, this is property. We have 8 embryos. We are a community property state. You get 4 and you get 4.
Mm-hmm.
And I think that would have been, I think, a defensible position. But the point here is that embryos are much more complicated, and everybody just sort of knows this is about more than just dividing property down the middle.
Right. And there are states that have treated embryos as chattel. Chattel is the legal term for property. So basically, we're going to take the emotions out of it and treat it like we would your dog. Interesting, in their divorce, their dog was also at dispute. And one of the comments in the article was it took Judge Steiner, 5 seconds to decide what to do with the dog, but the issue with the embryo was more complicated, right? Also, background here, and I actually read the appeal. So this went to the next step was the Arizona Court of Appeals, and then it went up to the Arizona Supreme Court, so the highest court in Arizona. And it's kind of interesting. So this is a case too. This is where I learned about these contracts, because really the dispute was about this contract that they had signed. And again, when everything gets politicized, and we're going to see that later because Arizona has now passed actual legislation as a result of this specific case. But really, when they went to this clinic, they again signed a contract that said, here's what happens when you get divorced. The problem is, the plot twist is that the language in the contract wasn't clear. So here comes the lawyers, right? And I'll actually pull it up because I think it's actually really interesting. Let me see here.
I'll pause.
Yeah. Oh, host is disabled. Okay, hold on.
Oh, you want to share your screen. So
Yeah.
Darren's going to show us the part of the appeal, and we're going to walk through the legal arguments. Now, spoiler alert, he already said this. Before the Court of Appeals got to rule, the legislature got involved. And that in and of itself is extremely political and controversial. And we're going to talk about that. But what did the lawyers argue on appeal?
Right. And the purpose of showing you guys this is because a lot of the outside commentary about this case has to do with, again, pro-choice, pro-life, but that really wasn't the discussion or the narrative at all. Ultimately, in court, it came down to the contract that the parties had signed with the facility, right? And the Court of Appeals goes through the contract. One of the paragraph 10 of that contract dealt with what happens, right? And it says paragraph 10 ultimately asks the parties to indicate joint disposition choices under different scenarios by checking boxes and initialing choices. Significantly, in the event of divorce or dissolution of their relationship, Torres and Terrell check the initial the first option provided. So in paragraph 10H. And this is what it said. In the event the patient or her spouse are divorced, or the patient and her partner dissolve their relationship, that would be divorce. We agree that the embryos should be disposed of in the following manner. Option A court decree or or settlement agreement. I can't read today. Will be presented to the clinic directing use to achieve a pregnancy in one of us, or donation to a couple for that purpose. So
Okay.
the reason why, and then box number 2 was destroy the embryos, right? So the reason why Judge Steiner employed this balancing test is because it was her interpretation of this specific paragraph, that the two options are donation or directing use to achieve pregnancy. And so she thought those were her two options, right? Which is why she didn't just pick up donation like out of her hat. It came from a contract, right? What is interesting though, and I don't want to get like too in the weeds here, but it's interesting because the Court of Appeals ruled in favor of Terrell, and said that the let's see um, basically said that the contract. Um, you know what? I'm drawing.
Okay, so Darren and I had to recap for a minute because even with his photographic memory, this is complicated even for us.
Yeah, yeah. No,
So,
this is well. There's some twists. There's some turns. You know, this is not your jot down to grandmother's house, as they say. I don't know if anyone says that, but I just did. Okay, so this is the Supreme Court of Arizona,
okay,
right?
so I
So
had previously said Court of Appeals. The Court of Appeals did rule on it. Then it went up to the Supreme Court, and somewhere in the middle, the statute was passed, which was not retroactively applied. So that's where we're at.
right, that's where we're at. So the Supreme Court of Arizona is this opinion. By the way, shout out to Stanley Murray, somebody who's we worked with in the past, excellent attorney. He was the attorney for the appellant in this matter. So shout out to Stanley Murray, and longtime friend of the podcast. Just kidding. Okay, so paragraph 10. So this is why Judge Steiner made her decision, right? Uh, when the parties created the embryo, the lab made them sign a contract defining exactly what would happen when they got a divorce or if they passed away. And the problem is the language of the contract was confusing, so confusing that Judge Steiner interpreted it one way, the Court of Appeals interpreted it another way, and the Supreme Court said, "Hey, look, we're the top dogs in town. Um, Court of Appeals, you got the interpretation wrong, right?" So here's the language, paragraph 10. In the event the patient or her spouse are divorced, or the patient and her partner dissolve their relationship, we agree that the embryos should be disposed of in the following manner. Checkbox 1. A court decree or settlement agreement will be presented to the clinic directing use to achieve a pregnancy in one of us, or donation to another couple for that purpose, right? And so that is why Judge Steiner thought that she had to do a balancing test. The universe of my options are donation, which is what she selected, or directing use to achieve a pregnancy in one of us, right? The other option, which is what Mr. Terrell was asking for, was destroy the embryos. Everyone agreed that that was not a viable option, because if it was the intended outcome, they would have checked that, right? So the question was really between, as far as the contract was concerned, and make no mistake, the court did treat this as a contract issue.
Mhm.
Um, so it's just an interpretation issue. So the Court of Appeals basically said that, well, we agree that there needs to be a balancing test, but Judge Steiner didn't balance the interest properly, and they reversed the trial court's decisions and said you should have found the balancing in Ms. Torres' favor. So we're ruling in favor of Ms. Torres, vacating the trial court's ruling, and Ms. Torres can have the baby, right? Uh, Terrell then appeals to go up to the Supreme Court and says, "Look, the Court of Appeals got it. The trial court got it wrong. Now the Court of Appeals has got it wrong. You're my last bastion of hope, right? Please help me out." So it proceeds, um, and the Supreme Court basically said the Court of Appeals got it wrong and the trial court got it right. And the reasoning here is kind of interesting because there was another part of the contract that that talked about, this is before paragraph 10, right, where they select the options. There was a part in explaining what the options would be that said, look, you got three options. One is to discard the embryo, two is to donate the embryo,
And
and
let's be specific
three,
because you can donate the embryo to science or you can donate the embryo for procreation. And this is interesting because if we're talking about the right, whether or not you can be forced to have a child, that matters. So the donation that was specific in the contract was for another couple to attempt a pregnancy.
correct, correct. So you can donate the embryo for the purpose of creating a pregnancy is option number two. And then number three, it can be used by one partner, but it said when in this description defining what the three options would be, in this section, it says with the contemporaneous permission of the other for that use, which means in real time. So the implication that the Court of Appeals drew from that was, well, it can only be used if both parties agree. And that's why they said Judge or the Court of Appeals got it wrong. And there was even a note to that section that I just referred to in the agreement that warned embryos cannot be used to produce pregnancy against the wishes of the partner. So they said, look, the fact that we're even having this discussion is ridiculous because the contract clearly says there's no scenario where an embryo can be used to create a child unless you agree to it. So now, this is getting politically charged. People are doing whatever they want. We just have to look at the contract. So the Court of Appeals said, the Supreme Court said the Court of Appeals got it wrong and they need to be donated. They said, look, the section that we talked about earlier that says that the divorce order or settlement agreement can either allow for use to achieve pregnancy or donation to another couple, uh, obviously only referred to use to achieve pregnancy if there was consent. If you look at the whole contract, here we don't have consent, so the court has no option but to donate, right? And therefore, Judge Steiner got it right. She may not have had the right reasoning because we didn't even need to do a balancing test, but she got the outcome correct. So that is the story of Terrell and Torres, right?
So, in the meantime, this becomes politically charged. You've got a very, very sympathetic plaintiff who says, I was going through cancer. I knew this would be my only shot to have children. He knew that was why we were doing it. We did it. I now don't have a uterus. I can never have children. This was our intention. And the facts surrounding that are pretty darn convincing. Then, of course, you've got this contract that is clearly contrary to it. And then you've got like the public interest or the philosophical, emotional, political idea that should there be a rule, should there be a rule that says what happens in this circumstance. And a lot of people weighed in. All sorts of people weighed in, all sorts of institutions weighed in, and it largely fell along very strict political lines of are you pro choice or are you pro life? And that that
Right.
that was where people weighed in. And one of the arguments was, of course, that no one should ever be forced to have a child against their will, that is a constitutional right. What do you think about that argument?
So that's interesting because I noticed that in Judge Steiner's, and listen, I'm not a constitutional scholar by any means, so I could be wrong about this. Disclaimer on that, but one thing I do know for certain is that people misinterpret Roe v. Wade all the time because I remember reading it in law school. It's a seminal piece of case law, and I distinctly remember reading it and having heard about it before I read it, thinking that it would say something completely different than what it says.
Right.
Right. Roe v. Wade does not stand for a constitutional right against procreation. What it stands for is a right to privacy, right? And the idea is so Roe v. Wade was decided because the anti-abortion legislation in that case was deemed to violate um, the um, the mother's right to privacy, right? Basically saying the government shouldn't be in the business of telling women to do uh, what to do with um, their bodies. So if we're following that line of cases, we would need to be able to tie it to a privacy interest. And in here, I think it's less easy to make that argument um, because the parties have entered into a contract, right? And uh, so it's just interesting because I don't necessarily think that you have a right against forced procreation. Um, if that were the case, then obviously, like fathers would be able to force mothers to abort children,
Right. There
right? I mean,
cannot
that's just a
be a right
logical,
against forced procreation because
right? You can't
all it
really
takes
have
is
it both ways,
accidental.
right?
Yeah.
Um, so whether or not the state has the power to make rules on this, I think is going to be remain to be seen. But it is really just a privacy issue, um, and the reason for that, just to get a little nerdy, is under the Constitution, you have a right to life, liberty, and the pursuit of happiness. Under the umbrella, so the Supreme Court in Roe v. Wade, or in some other cases, I think before that, basically said this liberty interest encompasses a penumbra of other rights, including privacy, right? And there's the same reason, by the way, why there used to be anti-sodomization laws on the books in like Texas and things where basically it was discriminatory against same-sex couples. And one of the legal reason those laws were overturned was because of this private issue. Like, why is the government legislating what happens in in the house? We should just shouldn't allow that, right? Uh,
Right. I mean, we have this general ideal in our Constitution that individuals should make choices. The government shouldn't make choices for us. That
right.
is that is replete throughout our Constitution. No doubt that is a fundamental value that we have in this country. Um, let's talk about what the legislature did in Arizona. They basically decided the Terrell Torres case and addressed the concerns of both Terrell and Torres in a statute that is a subset of how to divide property. So
Mhm.
this statute only applies to couples going through divorce. It would not apply to Sophia and Nick.
Yeah, so it doesn't apply to Sophie and Nick, um, and it basically creates a presumption in favor of whichever party wants to bring the embryo to birth, um, and it's a long and confusing statute, to be honest, but that's the gist of it. It also says that if a child is brought to birth under this statute and the other parent doesn't consent, the non-consenting parent isn't considered a legal parent and can't be held liable for child support or any other the duties that comes with when you have a child. Because in Arizona, as well as I think all 50 states in the United States, when you have a child, you have legal responsibilities and duties owed to that child, regardless of whether or not you wanted it. So it is kind of interesting because it creates an out, um, in a way that wouldn't otherwise be there, right? If you had traditional sex, um, you don't. You don't get to change your mind.
No.
You're responsible for the product of that. But if you
Right.
have a baby through in vitro, you can essentially opt out of child support and obligations, which I think is kind of fascinating, um, personally. Um,
I
but
like it. I like
yeah,
the statute.
well, it gives more options. Yeah, I mean, in it,
I think two people made a choice to create a potential life together. More
right,
so than even when you just voluntarily have sex. I mean, this was an
yeah.
active choice where you went to a place and you chose to make potential life. And it seems to me that I like that one person could choose to make life and the other person could be off the hook if they wanted to. It seems very fair to me.
Well, it does, and it would seem there would be an element of wrongness if you weren't consenting to the embryo coming to birth, but then you were on the hook for child support for 18 years. And I think both positions are sympathetic, and that's part of what makes this case so fascinating. It's really easy to relate to and understand Torres's position of, hey, I want to have a child, right? And this is my opportunity. I mean, that's relatable. That makes sense. It's hard to argue with it. It's the same thing with Terrell. Hey, I don't want to have a child, right?
I don't like
And
my ex.
right. Yeah, and I mean that could have been it or not, but it's still relatable. You
Well,
know?
the other thing that's interesting here is typically the statutes in Title 25, like 318, which is how to divide property, can be contracted around by two
Right.
parties through a postnup or a prenup.
Right.
Now, the question is, does entering into a contract with I suppose you could argue that a contract that was not consistent with Arizona law somehow violated public policy and was not enforceable. But the other argument is people can contract around statutes all the time. So, what do you
Well,
think?
yeah, in the whole statute seems to me because in the case of Terrell v. Torres, the Supreme Court dealt with the contractual issue because that was the whole analysis, and it wrote, um, neither party contests the family court must enforce contracts between a couple that directs the disposition of embryos in the event of a divorce. Such subject to defenses provided by contract law, we agree. Our courts traditionally have enforced contracts between divorcing couples regarding the disposition of property. That's ARS 25317, right? Providing that the parties may enter into written separation agreements directing property dispositions, and a court generally must enforce them. Okay.
Okay. However, if there is a contract that somehow doesn't abide by the law, for instance, if you entered into a landlord tenant lease that was against the Landlord Tenant Act, it would not be enforceable.
Right.
Would that
Right.
fly here?
Well, I'm sure there's going to be litigation over it, right? Because, like I said, if this apparently the reason why facilities require you to sign in advance what you want to happen is because they want to minimize any potential liability. They don't want to get dragged into a dispute, um, later on exactly like this. Because what happens if um, if they destroy an embryo based on a court order, that court order gets overturned. I mean, it's a disaster waiting to happen. So they actually want to have both parties' intent signed in writing so that they can say, this is what you wanted, this is what we did. Um, right?
Darren, I really don't think this issue is going away.
No.
Everything I'm reading lately, even today, is that our natural fertility might be going down and that we may need to rely on assistive reproductive technology more and more. And the litigation is just going to continue. It's going to be, very, very interesting to see how this plays out in Arizona and in other states.
Well, yeah, and I guess one thing I've been thinking as a practice tip is if you want to resolve this issue on both counts, it seems maybe wise to not freeze the embryo, but freeze the sperm and freeze the eggs, because that would seem to eliminate the issue altogether. And I mean, I'm not a scientist, but it's my understanding that you can freeze eggs, and then you can just find somebody who's willing to donate their sperm. and the issue is resolved.
Or maybe
Right.
do both, because I don't know what the outcomes are, and there might be a different outcome for embryos versus individual sperm or eggs.
Oh,
So,
wow, my brain's exploding thinking about that.
but maybe
Like,
you
do you have
do,
an interest?
maybe you
Do you
do
have an
both.
interest in your spouse's eggs? Technically, they were acquired during the marriage, which means they're deemed to be community property.
That
I can
seems
see
like
the
a big
argument.
no.
Yeah, exactly, right? But I mean, these are if we're considering these things as property, I mean, this is the problem. One thing is interesting. People forget altogether that your Congress can actually do things. They can create public policy. They can create laws to say this is how we want these issues um, to proceed. Obviously, subject to constitutional challenges. But it's fascinating to me that we have all these problems in the world, and we can't get legislation to address them. But something like this, it just boom passed.
Right, right, right. Well, it is a little bit simpler to come up with a rule on this issue than what do we do with all of the children at the border. That's not an easy law to pass.
Yeah, yeah. So anyway, I wasn't referring to children at the border. I agree that's a little more complicated,
It's
but
so
there are
complicated.
there are some issues that would be easier to resolve.
There are. You're absolutely right. And your point is a good one.
Yeah.
Sometimes people are so unhappy with the things that the courts are doing or the family court is doing or another court is doing, and sometimes your best option isn't to just talk to keep going to court. It might be to talk to a legislature and see if they agree with you.
Yeah. And one thing, that's always interested me is the fact that you can actually have amendments to the Constitution. I feel
Mhm.
like that has totally been removed from the repertoire of the American psyche, but
Yeah.
like some of the best things that we've ever done as a country in terms of eliminating slavery, giving women the right to vote, those were not done through some act of Congress like a legislation, but actually amendment of our Constitution. And I can't remember. I don't know when the last time we had a constitutional amendment was, but you can actually change the document if you don't like it.
Right. It's totally true. Well, thank you so much for this fascinating conversation today, Darren. Can't wait for next time.
Thank you.
Bye.